Welcome back. There's still a leadership vacuum at the Federal High Court as the presidency is yet to name a substantive CJ or confirm the appointment of the most senior judge, Justice Abdulkafarati, whose appointment as acting CJ of the court lapsed on March 16. It's an issue that many lawyers prefer to talk about in hushed tones, especially because many feel that the presidency has some information available to it which the public is not privy to and which is responsible for its foot dragging on the issue. But what are the implications of this leadership vacuum? I have the views of a few lawyers up next.
I'm very sure that the next most senior judge will act in that capacity till a substantive judge is appointed. But I feel that they should, as a matter of urgency, appoint a substantive CJ and don't try and politicize the position. I don't believe that the vacuum will be felt as such because most of the judges know what to do.
The situation will not call for any alarm as at now. The position of the law is clear on this point. By virtue of the provisions of the Constitution, which is the ground norm, when this type of scenario plays out, it is the president who is vested with the power to appoint the person who will take up the mantle of leadership. But the president cannot do it alone. It will be in conjunction with the recommendation of the National Judicial Council. So, but be that as it may, we look at the Federal High Court, we have judicial divisions. Each court has its own judge. The judges in those courts, in each of the judicial divisions, are vested, they are properly constituted to take decisions. So far, so good with respect to Federal High Courts. Such a decision is equally in order in the eye of law.
There are a lot of implications, far-reaching ones. For instance, the cases could not be allocated to the appropriate court where the head of the court is supposed to do that. And I wonder why this is happening. And I want to blame the office of the president for it. They are not acting timeously. Those of us that are lawyers know that the last hope of common man is the court of law in this country.
And now let's check out some of the top trending stories from the courtrooms.
We begin with the report that the Federal High Court in Abuja has expressed doubts about the claim of ill health made by the former National Public Secretary of the People's Democratic Party, Mr. Metuh. Justice Okonabang expressed this doubt while delivering a ruling on an application filed by Mr. Metuh seeking the release of his passport to enable him travel abroad for medical treatment for a spinal cord ailment. Justice Abang questioned why Metuh did not appeal two earlier decisions of the court which refused to release his passport. The judge held that it seemed like Metuh had a hidden agenda to present the court as inhuman by filing the same application a third time rather than going on appeal. He concluded that he cannot sit on appeal over his own judgment, having already refused the same application twice. Another Federal High Court in Abuja has fixed June 6 to hear the case of illegal detention filed by a pro-Biafra agitator, David Nwawusi, against the Department of State Services, DSS. Nwawusi, an engineer by profession, was arrested in connection with his purported involvement with the outlawed indigenous people of Biafra, IPOB, in 2015 and was initially charged alongside the leader, Nnamdi Kanu, and 3 others. In the application to challenge his detention, his lawyer told Justice Gabriel Kolawole that his client was arrested and detained for more than 6 months by members of the DSS without a court order. Justice Kolawole has ordered the issuance of hearing notices to all the parties and fixed June 6 to hear their application. Still in Abuja, a high court sitting in the Jabi area has heard the testimony of the first prosecution witness in the trial of the alleged murder of Biliamin Bello. The witness, Mr. Ibrahim Muhammad, a businessman and friend of the deceased, told the court that the wife of the deceased, Miriam Sanda, who the police charged with the murder, attempted to stab her husband multiple times on the night of November 18, 2017. The witness claims he was with the deceased from around 3 p.m. on November the 18th to around 1 a.m. on November 19. He narrated how he witnessed the wife threatening to cut off her husband's private part if he did not divorce her that night. The witness also said at some point the wife picked up a bottle, broke it on the wall and charged toward her husband, who subsequently overpowered her but sustained a cut in the process. After treating the cut, he said he returned home with his friend, stayed a while smoking and left for his home only to be called shortly that his friend had died. On the cross-examination, he maintains that the wife threatened several times to stab her husband but did not say that she would kill him. Justice Yusuf Halilu has adjourned to May 15 and 16 for continuation of trial. And in Akure, the Ondo State capital, the Federal High Court has dismissed a suit filed to nullify the suspension of Mr. Isaacs Kekemeke as the chairman of the All Progressives Congress, APC, in Ondo State. The presiding judge, Justice Folashade Olubanjo, declared that the appointment of Ade Adetimehin as a state acting chairman is in order. The court also held that the two plaintiffs, Boyega Adedipe and Desmond Edejumola, lacked the local standard to institute the case, as only Mr. Kekemeke has the power to challenge his suspension in court. A panel of investigation set up by the Executive Committee of APC in Ondo State had indicted Kekemeke for anti-party activities and recommended his removal as chairman of the party in the state, while Adetimehin, then the deputy chairman, was declared chairman in an acting capacity. And we round up in Delta State, where the High Court sitting in Kwale, Ndokwa West local government area of the state, has sacked the Deputy Speaker of the State House of Assembly, Mr. Friday Osanebi, over allegations of false information. The court ordered the Independent Electoral Commission, INEC, to immediately withdraw the certificate of return it issued him and issue same to Mr. Emeka Odegbe as a validly nominated candidate of the People's Democratic Party in the 2015 general elections. The court agreed with the complainant that a declaration of affidavit and documents submitted to INEC by Mr. Osanebi in respect of his nominations as a candidate of the PDP for the Ndokwa East constituency into the State House of Assembly elections contains falsehood and therefore renders him ineligible to contest the said elections.
And that's the program for today. Many thanks for watching. Please feel free to send in your comments via any of our social media handles. You can also watch this episode of the program or past ones on our YouTube channel. I'm Shola Sheyeli. Thank you for watching.